This is The Law Matters. Of course it does. Hi, I'm Debbie Morais, your host and moderator. As we tell you, this long-running program was created to educate, inform, and help you decide how to protect yourself, your family, and your business when it comes to legal matters. It's information and resources that'll help you determine whether or not you might want to handle some issues yourself. If you do decide to seek outside professional counsel, you'll be better prepared, and so will the professional that you select. As always, our goal is to help you save time, money, and achieve the best possible results. As always, we want to first welcome and thank, again, Attorney David Baza from the Baza and Associates law firm in East Providence, who shares his information and insights with us. And today, the two of us would like to welcome once again our guest, Attorney Harris Weiner, from East Providence, who has joined us before when we had talked about non-compete clauses and contracts. So we're happy that he's with us again today. And today our discussion is going to be about adverse possession. So what is this doctrine under which a person in possession of land owned by someone else actually could acquire title to that property? How does that happen, and why does it matter? And if you're the landowner, what can you do about it before it's too late? That's one aspect of it. There are conditions apparently under which it was once considered a good thing, adverse possession. Think of non-used farmland that's remaining vacant. Let's find an efficient use for it. But it's beyond that, of course. We'll talk about squatters and homesteaders and trespassers. And while adverse possession is usually discussed in terms of real estate and property, there's also a component that we may have a time to touch upon, which is intellectual property. So there's a lot to get going through, and let's begin. Let me toss the ball first to our guest. Can you explain to us, help us understand what exactly is adverse possession? How does that happen?
So adverse possession is a century-old doctrine, and it is the hostile use of your property by someone else. And if they can check off certain elements, certain requirements, they can actually take over ownership of your property. This is rarely granted, but it's on the books in every state. The length of time that they have to possess varies between 5 years and 30 years. It's 10 years in Rhode Island, 20 years in Massachusetts. There's a list of requirements, and the courts jumble them a little bit. So if a layperson just picked up an adverse possession decision and the statute, they would be confused because the terms tend to be archaic and they don't mean literally what they say. So if someone is supposed to be controlling my property to the exclusion of everyone else, that doesn't mean I can't walk across the property to defeat their adverse possession. It doesn't have to be absolute exclusion. The most common way to exclude other people is to put a fence on your property to my benefit as the adverse possessor. But you have to do it in an open way that is open to the public. Actual, open, and notorious are the first three elements.
Notorious.
And it doesn't mean, it's not notorious like Alfred Hitchcock
Right.
Notorious. It's notorious as in notoriety or notice.
Noted.
And it's putting the world on notice that I'm actually using your land. And that can be done in a variety of ways. It depends on the property, whether it's a woodland, that's way far from the highway, or whether it's a suburban piece of property, a commercial piece of property. Each one will be analyzed differently. But you have to take some action to show the world that you are in possession. And you don't have to give everybody notice. You can put something in the land records, And that would be constructive notice to the world. Your mortgage and your deed are available to everyone. They're in your local land records. And that's considered good notice to everyone. So that's one way to do it. Another way to do it is to make obvious improvements and to move onto the land in some respect. So the case law generally clusters together actual, open, and notorious as the first requirements. Then it's got to be exclusive, as I just mentioned. Exclusive meaning I'm not letting anyone else use this in the manner an owner would use land. That doesn't mean that I'm preventing kids from kicking a ball across, or someone's dog from straying across, or actually someone walking on a semi-regular basis across the land. I could still maintain exclusivity even with some minor incursions by someone else, depending on what the land is. The best way to establish exclusivity is a fence or a wall. The next best way is probably signs, no trespassing. Another way of showing your adverse possession is to improve the property. Cesspool, structures, and short of physical structures, drainage, things like that, then hanging things, a hammock, items on a tree, putting furniture there, parking cars on the land is a good piece of evidence of adverse possession. Adverse possession, so we've dealt with open and notorious. Now we dealt with exclusivity. It has to be continuous. So you have to have continuity for at least 10 years.
In every state or
Rhode Island?
In Rhode Island.
Continuity for 20 years in Massachusetts.
Okay.
Idaho, I think, is 6 years. I mean, it varies.
Okay.
And the length of time is sort of arbitrary. There's no magic period nationwide. It really depends on how property law has developed in that particular jurisdiction. So after you deal with exclusivity, continuity for 10 years, what am I leaving out?
You got it all. It's open, continuous, adverse, exclusive, and notorious.
Okay, and you can't, and hostile. And hostility, which is a standalone element, is not, being pugnacious. It's not, causing confrontations. It means that you are using the land in a manner inconsistent with the owner's rights. That you are asserting a claim of rights over this land that is contrary to what the owner has.
So in the occasion that this might be a good thing, namely fallow, untouched land, could suddenly be planted, which is a good use, certainly. Mm-hmm. No one would dispute that. That's clearly different, and it's clearly not what it was intended for at the time. Maybe the person wanted to leave it fallow for X number of weeks, months, years, or whatever it is, to restore the nutrients to the property, or however you defend that. Is that an example of it being hostile because it was clearly not what the owner had intended?
Well, parking cars on your land is hostile.
Yes.
Putting claims in the land records is hostile. Planting trees is hostile. Putting in a sewer or a septic system or a drainage system, those are all hostile acts that are in conflict with your ownership rights. That's what hostility means. And the courts are still wrestling with that idea. Every fact pattern presents a slightly different wrinkle to that analysis. But again, it doesn't mean literally hostile.
Okay. So David, how do you find incidences of this happening frequently, more frequently, less frequently than?
I think it comes up more often than it should.
Okay.
I think oftentimes neighbors are the ones who end up with these types of conflicts. Sometimes someone puts a garden on somebody else's property, or they put the fence over the line. They do certain things, maybe intentionally, maybe unintentionally.
How does that make a difference? I read somewhere that sometimes it doesn't matter. I might not have known that that was not on my land or was on my land. How does intentionality factor into this?
You were right that it basically doesn't. You can be black-hearted and predatory in your adverse possession, and that doesn't disqualify you. So the court is not looking into your motivation. There was a really interesting case a couple years ago, Carroll versus Rodriguez, where someone was looking for land that was not on the tax rolls and found some land, and they deeded it to themselves and recorded the deed. Then they improved the land, and they put up fences, and they subdivided it, and they paid taxes on it. Someone else owned it. They did this for 13 years, and the court gave it to them. And but they knew the law very well, and they addressed each of those factors
one at a time.
And yeah, maybe they put it to more productive use, but does that justify stripping someone of their property rights?
Does it?
Property rights are sacred. The only one who has superior rights to your land is the king.
Or the government?
The king.
The king, okay.
The king, the government. So our property laws descend from England.
Yes.
The king owned everything. So there would be disputes among landowners who were primarily illiterate and farmers, or raising livestock, and they couldn't, so the land records were fuzzy. So possession was the best indicator of who should own the land. If you were grazing on that land, if you were putting fences on that land, if you were using it productively, it would become yours. And that was the simple solution back then. But it is considered, even the courts have said in dissents and in dicta, which is not controlling, we have to rule in favor of this adverse possessor, but we hate this doctrine. It's archaic, it's unfair, it violates people's sacred property rights.
Historically, as you were talking about it, going back to the American frontier, moving west, the Turner doctrine. The whole idea was we wanted to encourage people to move. The federal government owned land that you could buy or obtain either free or very inexpensively. Other people may have owned land. And so when you're saying that somebody in New York who owned land in, did you say Idaho, 6 years? Mm-hmm. And they have land that's not being used, and you go and you put your fence on it and you farm it and you do it for 6 years because we want to encourage the use of that land, that was a different time and a different way of doing things. I don't think you could take federal property by adverse possession.
No, it doesn't work against the government.
Right.
Sovereignty trumps the common law and state statutes.
Right. Which is why you had to either get it deeded to you by, you could park yourself on the land back then, we're talking, 1800s, and acquire the land either by purchase or by grant. But the land that was privately owned, they wanted to encourage people to use it. I kind of think that's where the doctrine grew up. But it's totally different now between neighbors, and Harris has litigated these things. I have had these things. I often try to resolve them because the best way for neighbors to get along is for neighbors to get along.
So, David, we talk during each session, there are times when people can DIY, they can do it themselves. Seems like it should work out that if you had two neighbors that were in disagreement about where the flowers are planted and which tree goes where, wouldn't it be nice if people could just plain talk it out and deal with it and do it themselves? But we know that that often doesn't happen, and it ends up in your court. If it's yours or Harris's, if that's the case, is that kind of a situation with where the tree is planted or whether the garden is growing 3 feet on the neighbor's property? Is that something that anyone can DIY, that they can take it to a court themselves, or do they really need to hire an attorney right away to flesh this out and get excavated, architects to check it all out? How does
Surveyors.
that go?
It's not the type of case that you're going to try yourself. It's got too many factors, too many complications, and too much development of the law to understand what judges would be looking for and what needs to be presented for evidence and how to even get that evidence. It is, however, something that the two neighbors could work out between themselves, but even that, I would then say, go to a lawyer so that you can have whatever agreement you've reached drafted so that you either don't lose the property, or if there's going to be some concession, it's spelled out so it doesn't grow and creep and change.
Permission is a very important concept between neighbors. If I give you permission to put up a fence within the 10-year period, you can't assert adverse possession for that period. If I give you permission to come onto my land, it's not trespass. If I don't give you permission and you intentionally come on, that's a simple definition of trespass. And trespass is both a criminal act and a civil tort. Now, it's hard to prove any damages from a trespass, but I can get an injunction. I can keep you off my land. I just did that successfully with the Superior Court. But permission is a defense to adverse possession.
Good to know.
A break in continuity is a defense to adverse possession. Use by many people in many different ways are defenses.
So to your earlier example where someone took over a piece of land and then subdivided it, would that count as not exclusive, or you are exclusively handling it and you chose to subdivide it? Does that still count?
That counted as a hostile act.
Okay.
You can also, if say you haven't owned the property, but the fence has been onto your neighbor's land, you bought the house that way, and you want to assert adverse possession, you can tack on to the prior owner's time. So if the prior owner put that fence up 8 years before you bought, you wait 2 years, then you can file for adverse possession. You can, on the other side, to defend against it, you can file the agreement regarding permission in the land records. I did that with my neighbor. They asked me if they could put a fence up along our property line. I said, sure, let me write up an agreement that says this is not adverse possession, this is permissive, this is, an accommodation, because they might have been 2 inches or 1 inch into my land.
So when you did this, did they have to sign it too? You
Yes.
drew it up?
Yes.
They have to sign it, and then it's on record?
It's always good to have the opposite party sign the agreement to show that they acknowledged it. If I sent them a letter by registered mail giving them permission, that would be evidence, but not as conclusive.
Good to know.
And there's also a statute where there's a mechanism, if you know that they're trying to adversely possess some of your property and the 10 years haven't run out, there's a statute you can use to give notice by constable to them and into the land records to say, I am cutting off your clock. I am asserting my rights, and your clock stops as soon as I file this in the land records. And then the other way is to file suit. So as soon as you file suit, you stop the clock.
So is that the court of last resort, or there are other things that you should do first and then file suit if all else fails?
You should negotiate first and say, I'll sell you that strip, or I'll sell you those 2 inches, or I'll swap this swath with something else I want on the other part of our boundary. If that doesn't work, then you should take legal, stronger legal steps.
So address, if you will, the idea of what an easement is, this being a situation where there's a driveway, there's a situation that you have crossing across paths, and how does that happen, and what's the distinction, and what do you do about that?
There you
Can
go.
we take it?
Yep.
An easement is a property right to cross over land, and it's usually a defined corridor, like beach access,
Okay, good example.
or access to parking or to the lake or whatever. And it's usually part of your deed. You want it to be in the land records. It goes with the house, it runs with the land, as they say. And so those are very important rights to a lot of people. Otherwise, their houses might be landlocked, or they might not have the amenities that they wanted. The difference between land under adverse possession and an easement is that an easement's not exclusive. There could be 10 property owners sharing that easement to the beach. But otherwise, the analysis is the same. It's not called adverse possession, it's called easement by prescription. And, it follows the same concept.
By prescription, does that mean you can only do one thing? You can walk across that land, but you can't drive 4 cars and 6 boats and put up a tent and I don't know, whatever else someone might imagine?
That's right. You can't obstruct other users. You can use it in a certain manner. I would bet there are easements on your property you don't even know about. The gas company, the electric company probably have utility easements underground that there may be something on file in the land records, but not particular to your house. It might be the whole plat. But we are surrounded by easements. Some are for different purposes.
Let's talk about the idea of what squatters and homesteaders are versus someone who was a renter and stayed too long, and whether or not they get an opportunity to say, yes, I want that property now. What's a squatter? What's a homesteader?
Well, I think David was describing homesteaders, the people who were on horseback racing through Oklahoma to try to grab a nice piece of land.
That's exactly right.
Those are homesteaders getting federal land.
Yep.
A squatter is someone who does not have a right to be on the property, but it can ripen into adverse possession. Frequently squatters are in condemned buildings, and the police don't get around to moving them out. They're there illegally, and usually in a dangerous situation.
Yeah. I think there was something in Worcester a while back where there were a lot of squatters in an abandoned building that actually caught fire.
Right. And don't confuse the word condemnation in the context of a blighted building with the government's capacity to condemn property in eminent domain. So that's another real estate concept that's very important, and that goes back to the king owning all the land. If the king wants it, the king can take it. Eminent domain in this country means taking private property for public use and paying just compensation as required under the Fifth Amendment of the Constitution. And it's not that common, but that's how they build roads, bridges, prisons, schools. There's a lot of land surrounding us. We're in East Providence now, but there's a lot of this land that was taken by eminent domain by the state, and sometimes the state would delegate that power to the municipalities who don't have that inherent sovereignty. But it can be delegated by the General Assembly to individual municipalities. They create quasi-public corporations that gobble up land.
Like airports.
Like airports
Another example.
and runways and things like that. The controversy there is when they take your property and they give it to another private entity for profit, and they call it economic development. And so there's been a backlash against that type of taking. And the Rhode Island General Assembly built into the laws some penalties for that and some obstacles to that. They took a lot of land in Smithfield for the Fidelity campus. That's an example of economic development. They took away from private individual owners and gave it to Fidelity, ultimately.
Good example. I wanted to cover one other issue which came up. It had something to do with a renter who, whose lease had come to its conclusion, and they stayed. And while they stayed, they fixed the lights, they did something to improve the property, and they stayed a long time because the landowner, didn't say, we need to usher you out, get a sheriff, or however they might do. What's their opportunity then to have adverse possession, say, I've been here 6 more years, 10 more years, whatever, and now I own it? Can that happen?
No.
Good.
No, if there's a lease, the eviction laws apply.
Right.
So you have the Residential Landlord-Tenant Act in Rhode Island, that's administered exclusively by the district court. Appeals go up to the Superior Court. And then you have commercial evictions that follow those basic principles. And, you know, if you go through the procedure, you could have them removed from the property.
And the tenant was there paying rent initially with permission to be there. So they had permission. They're there with my consent.
Good, good distinction.
But yeah, holding over does not
Holding
give
over.
you an opportunity to adversely possess the property. You know, maybe under the wildest hypothetical it could, but I've never seen it in any practical terms.
Good to know. And in the very little time that we have left, I guess there's also some discussion now about the idea of intellectual property, which is even murkier and more difficult to lay claim to, where there are a lot of people who want to claim patents. There are a lot of trollers. Is that adverse possession also being used currently, even if it's a stretch, to try to access intellectual property as property?
No, I wouldn't apply that real estate concept to intellectual property. I mean, you mentioned patent trollers. There are people who are predatory and are looking for inactive patents, buying them cheaply, and then trying to find people in business who are in closely related industries and to say, you're violating my patent, and if you don't pay me ransom, I'm going to sue you. And so they have an inventory of patents purely, you know, as an investment, and it's immoral.
And so, speaking as we did earlier about the productivity or the use of it, if someone's not using it, that doesn't give someone else the right to say, I am going to use it and can. You just haven't done anything. Like, you didn't do anything with the property. You didn't do anything with that patent. I have access, and I'm going to see if I can snitch that intellectual property. Not okay to do.
No, that doesn't work.
Good to know.
Yeah. And they might be able to get treble damages under federal law.
We thank you. We thank you for tuning into The Law Matters. We hope that this has been helpful to you. Please continue to stay tuned to The Law Matters. It matters to you.